in the appeals classing children.
Lord Wilson will summarise the decision of the court.
Sometimes a court needs to determine whether a child's residence in a country was habitual. How relevant to that determination is the child's own state of mind while resident there? The appeals concern 4 children, namely T, a girl now aged 13, and 3 boys now aged 11, 9, and 5. Until July 2012, they lived with their British father and their Spanish mother in England. The parents' marriage broke down, and in July 2012, with the father's reluctant consent, the mother took the children to live in Spain. They lived there until December 2012, when they returned to England to spend Christmas with the father. They were supposed to return to Spain on 5 January 2013, but the 2 older boys hid their passports, the plane was missed, and all 4 children have remained here ever since. The mother swiftly brought proceedings here, pursuant to the Hague Convention 1980, for an order for the immediate return of the children to Spain. The first question for the judge was whether they had acquired a habitual residence in Spain during those 5 months. He decided that they had, and therefore that it had been wrong for the father to retain them in England after 5 January. He went on to decide that none of the narrow exceptions to the court's obligation to return the children to Spain applied, so he ordered that all of them should go back there. The father and T appealed. The Court of Appeal disagreed with the judge on only one point. It decided that, in the light of the strength of her objections to returning to Spain, it was not appropriate to send T back to Spain. That raised the possibility that another exception might apply in relation to the boys. For if they went back, it would now be without T. So would that place them in an intolerable situation? The court remitted that question to the judge, who has not yet determined it. The father and T, supported by the 2 older boys, now appeal to this court. They argue that none of the 4 children ever acquired habitual residence in Spain, and that the mother's application should have been dismissed on that basis. The basis for the dismissal matters because unless it was that they were not habitually resident in Spain on 5 January 2013, the Spanish courts could still, in due course, order the children back, and the English court would have to comply. That is the effect of Article 11.8 of a European Council regulation dated 27 November 2003. Today, this court unanimously sets aside the judge's conclusion that the children were habitually resident in Spain on 5 January and directs a fresh determination to be made of that issue. Prior to the hearing before the judge, a CAFCAS officer interviewed T and the 2 older boys. The upshot was that they, particularly T, did not want to go back to Spain. In the course of the interviews, they, again particularly T, made comments about their life in Spain in 2012, which, on one view and if taken at face value, indicated that they had not felt settled there. It has recently been established, both at a European and at a domestic level, that a person is habitually resident in a country if he or she has achieved some degree of integration in a social and family environment there. The consequence is, as this court unanimously holds, that a child's state of mind during a period of residence in a country will sometimes be relevant to whether he or she was integrated in that environment and therefore to whether the residence was habitual. At this point, however, a difference of emphasis arises among the 5 justices. Three of us consider that it is principally the state of mind only of an adolescent child, in the case, therefore, only of T, which might occasionally be relevant. They are doubtful whether the state of mind of, in this case, the two elder boys, could, alone, alter the judge's conclusion about their habitual residence. Their conclusion that the judge should reconsider the habitual residence of the three boys, as well as of T, is primarily founded on a different hypothesis, namely that, in the light of the apparent closeness of all four children, T's continued habitual residence in England, if such it turns out to have been, might impact on the habitual residence of the boys. But the two others of us would have held that the state of mind of younger children, say school-age children, can, in principle, be as relevant as that of adolescent children to their habitual residence. So they would have been prepared to countenance the judge's possible attachment of greater weight to the state of mind of the two elder boys while resident in Spain, even though they were then aged only 10 and 8.
Thank you. The court is now adjourned.